Hey there, I'm Paul Rabalais, and you should watch this video if you or someone you know is worried about losing everything they own if they need long-term care in the future. So this video is part of a playlist I have created that will, when I am done, contain about 8 videos that address people's biggest estate planning objectives and how to address them. The playlist was created out of a need to get people away from thinking generically, I need a will, or I need a trust, to I have certain concerns about my estate and my heirs. Here are what those concerns are, and let's discuss a solution so that I don't have to worry about that anymore. So I made a video, I'll link you to it above, that describes 7 estate planning concerns people commonly have. Now in this video, I am going to address one of those concerns, which is commonly expressed to me as, how do I protect my estate if I have to go in a nursing home? Now, most people have no desire and no intention of ever residing in a long-term skilled care nursing facility. But like countless people have told me in the past, Mr. Rabalais, I don't want to go to a nursing home, but we can't accurately predict what will happen in the future. And since one day I may get to a point where nursing home care is required, I want my assets to be protected just in case. Now, before we get into how to protect your estate from nursing home expenses, if you are wondering whether Medicaid planning is right for you or someone in your family, I think you should watch a recent video that I made and will link you to above entitled 9 Reasons Not to Protect Assets from the Nursing Home. After watching that video, you'll see why I tend to talk more people out of Medicaid planning than I actually help people reposition their assets to qualify for Medicaid. But if after watching that video, you feel that protecting your assets by engaging in Medicaid planning is right for you, then let's march on. Before we can talk about the actions that you can take to protect your assets from nursing home poverty, it's important to understand basic Medicaid rules. Note these rules can vary slightly from state to state, but the rules in your state may be pretty close to, if not identical, the general rules that I'm about to tell you. Let's start with the rule about the value of your countable resources. Some people simply call countable resources assets. If you have too many countable resources when you go into a nursing home and apply for Medicaid, you will not qualify for long-term care Medicaid. If you want or need to stay in that nursing home and you do not qualify for Medicaid, you will have to pony up the $7,000 to $12,000 monthly cost. You'll get no help from the government. And note that Medicare does not pay for long-term care expenses. So what are countable resources? Well, in general, they are any assets you own that do not include your home or a vehicle. Countable resources include any bank or credit union accounts, whether those accounts include checking accounts, savings accounts, or certificates of deposit, any cash you have, any contents you own in a safe deposit box, any stock that you own, any investment accounts, cash value of life insurance policies you own, annuities, rental property, full or partial interests in land, or any interest you may own in a small business. And in some states, your IRA and retirement accounts are countable resources. But in some states, those retirement accounts are not countable resources if you are taking required distributions. So what are the limits on the amount of countable resources that you can own when you enter a nursing home and apply for Medicaid? Well, it ain't much. If you are a single person, unmarried, your countable resource limit is only $2,000. And if you are married and both spouses are in the nursing home seeking Medicaid qualification, their combined countable resources limit is only $3,000. And if you are married and only one spouse is in the nursing home, this spouse is called the institutionalized spouse, while the other spouse is not in the nursing home, this spouse is called the community spouse because they are still living in the community. That couple's countable resource limit for the year 2022 is $137,400. The rationale is that the community spouse who still lives at home or in the community somewhere needs some assets to live off of. Okay, since you are watching this, and if you are married, you probably have more than $3,000 of countable resources, you may be thinking, How do I get my countable resources down to the limit so I can qualify for Medicaid if I go into a nursing home in the future? You might be thinking, I'll just put those countable resources in my kids' names right before I go into the nursing home. Problem solved. Well, not necessarily. You see, you are not the first person to think of that. So let's discuss the rules regarding uncompensated transfers. Now, when and if you go into a nursing home in the future and complete a long-term care Medicaid application, because you would prefer that Medicaid pay the monthly nursing home expense, you or someone on your behalf will complete a Medicaid application. On that Medicaid application, you will be asked not only to list all of your countable resources, but you will also be asked, have you transferred any assets out of your name in the last 5 years? And if you answer yes to that question, you will not be eligible for Medicaid. So with all of that being said, most of Medicaid planning involves getting assets out of your name 5 years, at least 5 years before you enter a nursing home, so that when you enter a nursing home and they ask you, what are your countable resources? You can say $1,500 or some answer that is under the countable resource limit based on whether you're single or married. And when they ask you, have you transferred assets out of your name in the last 5 years? You can truthfully and without committing Medicaid fraud say, nope, I haven't transferred any assets out of my name in the last 5 years. So another issue involved in Medicaid planning is if you are going to transfer assets out of your name, who do you transfer them to? It generally doesn't do any good to transfer them to your spouse. So most people transfer their assets either to their children or to a particular type of irrevocable trust where you cannot, under any circumstances, be a principal beneficiary of that trust, or rather, you cannot be entitled or authorized to use any of the trust principal for yourself. Either way, whether you transfer your assets to children or to that certain type of irrevocable trust, the same 5-year penalty applies. And it is probably worth noting that a transfer of assets to the common, avoid probate, revocable living trust does no good for Medicaid planning purposes because since you have the right to revoke that trust and use the trust principal for yourself, those trust assets will still be considered countable resources of yours. Another issue around Medicaid planning is that even if you get all of your assets out of your name timely and you pass the asset test, you will still have to apply some or all of your monthly income, like your Social Security income and any monthly pension income, to the nursing home, and Medicaid will generally pay the difference between your income and the cost of the care. So the moral of the Medicaid planning story is don't wait until you are on the doorstep of the nursing home if you think that repositioning what you own in order to qualify for long-term care Medicaid is something you need to do. And make sure you like, subscribe, and comment. Your comments to these videos and your opinions and shared life experiences can and do help others who are using this channel to gain knowledge in order to make informed life decisions. Have a great day and have a great life.